Following a referendum, various provisions of the Government of Wales Act 2006 came into force on the 5th of May 2011. Those provisions gave the National Assembly for Wales primary legislative competence in certain areas. The first bill to be enacted by the Assembly under these new powers was the Local Government Bylaws Wales Bill 2012. The aim of this bill is to simplify procedures for making and enforcing local authority bylaws in Wales. To this end, certain provisions of the 2012 bill are intended to remove the need for confirmation of bylaws by the Welsh ministers and by the Secretary of State. This need arises because subsection 11 of section 236 of the Local Government Act 1972, as amended by Schedule 1 to the National Assembly for Wales Transfer of Functions Order 1999, provides that the function of the Secretary of State to confirm certain bylaws made by local authorities is exercisable concurrently with the Assembly. The Attorney General referred to the Court the question of whether sections 6 and 9 of the 2012 bill were within the Assembly's legislative competence. Section 6 would remove the Secretary of State's function in confirming or refusing to confirm bylaws made under certain specific statutory provisions set out in Schedule 1 to the bill, where that function is exercisable concurrently with the Assembly. Section 9 would give the Welsh ministers the power to add other statutory provisions to those listed in Schedule 1. For the purpose of deciding this reference, the essential point is that it would be beyond the legislative competence of the Assembly to remove or to delegate to the Welsh ministers the power to remove the Secretary of State's function unless it was, and I quote, incidental to or consequential on any other provision contained in the Act of the Assembly, by virtue of section 108 and paragraphs 1 and 6 of Schedule 7 to the 2006 Act. We've concluded that section 6 is within the legislative competence of the Assembly. Section 6 does remove the Secretary of State's confirmatory function in relation to statutory provisions set out in Schedule 1 to the 2012 bill, where that function is exercisable concurrently with the Assembly. However, this removal is incidental to and consequential on the primary purpose of the 2012 bill, which is to remove the need for confirmation by the Welsh ministers of any bylaws made under those provisions, and more generally, to streamline and modernise the procedure for making bylaws in Wales. This, the primary purpose of the 2012 bill, could not be achieved without the removal of the Secretary of State's confirmatory function. The fact that the Assembly and the Secretary of State have a concurrent function means that each of them can, as a matter of law, exercise that function. And it was left to their good sense to decide which of them should exercise a particular function in a particular case. The statutory provisions set out in Schedule 1 to the 2012 bill relate to bylaws in respect of which it is very unlikely indeed that it would be the Secretary of State rather than the Assembly who would exercise the confirmatory function. For essentially the same reason, we've also concluded that Section 9 is within the legislative competence of the Assembly. That is because Section 9 must have a limited effect. As explained, paragraphs 1 and 6 of Schedule 7 to the 2006 Act limit the jurisdiction of the Assembly to remove or to delegate the power to remove functions of the Secretary of State, where this would be incidental to or consequential on any other provision contained in the bill. Accordingly, the Assembly cannot bestow wider powers than this on Welsh ministers. Therefore, in response to the Attorney General's reference, this Court declares that the Assembly had the legislative competence to enact Sections 6 and 9 of the 2012 bill. While this outcome is in favour of the Assembly, it cannot be regarded as a setback in practical terms for the Secretary of State, because the conclusion of the Court has reached as to the effect of Section 9 of the bill is one which reflects the terms on which the Secretary of State was prepared to give consent to Section 6 of the 2012 bill. More broadly, the outcome is entirely consistent with the general thrust of the extended powers given to the Welsh ministers by the Government of Wales Act 2006.